All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Be seated. Good morning and welcome to the January 8th, 2026 setting of the 7th Court of Appeals. The first case on this morning's docket is 07-25-00150-CR, Courtney Donovan Gage versus the State of Texas. What says appellant?
Judge McGraw for Mr. Gage from the Bureau.
Thank you. And what says the state?
Gabriel McClure for the state of Reading.
Each of you will have 20 minutes to argue. The appellant will have an extra 5-minute rebuttal. Any questions before we get started? Great. Ms. Groff?
Good morning. May it please the court. Your Honors, this case is about the fundamental principle that the state is not allowed to poison the well with aggravating character evidence before guilt is adjudicated. And there are 2 reasons that this court should reverse and remand to the lower court. First, due process and the Code of Criminal Procedure require the court to decide whether a violation occurred before the state may introduce aggravating punishment evidence. And second, the Confrontation Clause applies in revocation proceedings, and the state cannot prove a violation through testimonial hearsay. Now, turning to my first point, both due process and Code of Criminal Procedure Article 42A.108 entitle the defendant to an adjudication decision before the state can introduce punishment evidence.
In your intro just a minute ago, you said it has to determine that a violation has occurred. Didn't the trial judge say a violation had occurred at that point?
No, Your Honor. He said that the state had made a prima facie case, but he explicitly refused to make the ultimate finding that a violation occurred. And the judge did so acknowledging that, the defense could put on evidence rebutting that there could be an excuse for the violation that would not result in adjudication. And so at that point, there was not the finding that would then allow the state to go on and move on to the punishment phase after a single witness, he had testified to a few alcohol violations from a year before. Now, the Court of Criminal...
So that would have been sufficient, just one violation to have adjudicated.
Correct, Your Honor. It would have been sufficient, and we're not challenging the sufficiency of the evidence here. What we are challenging is the due process violation by allowing the state to put on its most aggravating character evidence before the court even made that determination that adjudication would happen. The Court of Criminal Appeals...
And you're not disputing they do all that in one proceeding. You're just disputing the order.
Exactly, Your Honor. There's not required to have... a different proceeding on a different day. The Court of Criminal Appeals has held that. But there is a sequence of events that must be followed if the defense asks for it, which is what happened here.
If you're not contesting the underlying evidence that the client consumed alcohol in violation of the terms of community supervision, how is there harm under the constitutional analysis?
Because even if he had committed that violation, that didn't require the judge to adjudicate. Even under the statute, if the judge finds a violation, he can still decline to adjudicate guilt at that point and continue on with the community supervision, which had happened an earlier time in this case.
So this was the second motion to revoke or to adjudicate, right?
Correct. So the judge absolutely could have said at that point, I find the violation, I'm adjudicating guilt right here, let's move on. He explicitly declined to do that. And that's because he recognized the defense hadn't had enough of an opportunity to contest or, as the CCA recognized in Euler, to present an excuse for the violation that would convince the court that adjudication was not the appropriate result. The Court of Criminal Appeals has addressed.
I want to go back to something, your answer to me, you ended with, if the defense asks for it. Why do you say that on the order?
Sure, because the Court of Criminal Appeals has said that, a due process right, for example, the right to present mitigation, has to be requested by the defense in order to preserve error.
And that
So-
happened here.
Yes, exactly, Your Honor. The defense asked to bifurcate the proceedings, actually at the judge's prompting. Do we want to bifurcate? Yes, Your Honor. The judge kind of makes the odd decision of initially saying, okay, we'll start with bifurcation. They put on their first witness and then specifically declines to adjudicate. The defense objects again, overrules the objection, and then that proceeds. Now, the Court of Criminal Appeals, in addressing a similar but flipped situation, has provided principles that I think will carry the day here, even though they aren't the exact scenario. Now, the CCA has never approved of what have happened here, right? Aggravating punishment evidence before the court decides whether to adjudicate. But when they address the opposite problem, which was courts refusing mitigation evidence after adjudication, we can see kind of two core principles from those cases. First, in Euler and Issa, the CCA established that due process protections do apply in deferred adjudication or revocations hearings, and that ultimately goes back to the due process principle of fundamental fairness. So the CCA emphasized there that the defendant has to have the opportunity to present mitigating evidence that both that he didn't violate the conditions, and even if he did, that adjudication is not appropriate. And as long as he is given that opportunity, due process is satisfied. The second thing that we can see from these cases and from the statute itself is that punishment is a separate inquiry from adjudication, even if it is not always a separate hearing, right? That comes straight from the statute, that the defendant is entitled to a hearing limited to determination of whether the court is going to adjudicate. And after the court makes that determination, then punishment proceeds as usual, as if there was no community supervision in between the guilty plea and punishment. The CCA made clear that it doesn't violate fundamental fairness and therefore due process for the judge to hear mitigation before adjudication. But our argument is that aggravating punishment evidence is different. The mitigation evidence would be about liberty interests, helping the court decide whether revocation is appropriate, even if there was a violation. But this is the exact opposite. The state acknowledged this was pure punishment evidence. It had nothing to do with adjudication. And before the court decided anything, it heard that Mr. Gage was a violent abuser, that he was a sexual perpetrator, a stalker, a manipulator. None of that made a violation any more or less likely. But still, the state was allowed to put that on. Now, as we previously discussed, this is kind of a weird situation, and the court said, I'm going to bifurcate, and then ultimately doesn't do it. But there are a couple of important points about that. And I think first, the court never said that it was going to set aside Mr. Gage's wife's punishment testimony until after adjudication. The court could have said, for scheduling reasons or whatever, perhaps we'll have her testify and then proceed. But that didn't happen, right? The court is saying, I'm not adjudicating right now. I am going to consider that evidence, and then the hearing proceeds. So there can't be any sort of separation in the court's mind that we can find from the record itself. And from that moment on, after Mr. Gage's wife testified, all of the other evidence of violations was heard through the lens of the worst version of Mr. Gage. And this is harmful beyond a reasonable doubt. Now, what the state would have to show to prove harmlessness is that this violation in the sequencing by putting on this punishment evidence first did not contribute to the adjudication. And the state can't do that here for a couple of reasons. First, the court only found the allegations true after it heard the testimony of Mr. Gage's wife. So we can't remove that influence from the rest of the evidence the court heard subsequently. Second, we can't say beyond a reasonable doubt that the court would have chosen to adjudicate guilt and revoke at that point over alcohol and travel violations, especially when the first alcohol violations that the court heard were a couple of glasses of wine from over a year ago. The travel violations were heavily contested. It appeared that Lubbock initially gave Mr. Gage sort of an open travel permit, and then that was later revoked, and there were issues with communication between his Terry probation officer, and even his probation officer acknowledged that the prior probation officer would give verbal approvals for travel and then not note that in the file. So there were a lot of contested issues there. And with that, we can't conclude beyond a reasonable doubt that had the court not heard this damaging punishment evidence first, it would have chosen to adjudicate. Now, turning to my second point.
Before we go to the second one, you would agree, though, towards the end of the proceeding, when he says, I find violation, 2A, 2B, that was an adjudication.
Absolutely, Your Honor.
Okay. He didn't have to say guilty.
No.
Okay.
No, he just had to determine we're going to go ahead and adjudicate guilt. And once that was done, then the court was open to considering the full statutory 2 to 10-year range of punishment. Now, as to whether the confrontation clause applies in deferred adjudication revocation proceedings, there is a split among the courts of appeals over this, but the better reasoned authority holds that the confrontation clause does apply. Now, the courts that hold that it doesn't are doing so based on the idea that revocation is not part of the criminal prosecution, but that reasoning is outdated. The Court of Criminal Appeals hasn't decided this exact question, but its precedent all points strongly toward applying the confrontation clause at revocation.
Have we addressed it?
Not since Ex parte Don, Your Honor, in 2012, where the CCA held that a revocation proceeding is not administrative. Prior to that, the court had held it's an administrative proceeding. All of the courts, the lower courts, including this one, had universally applied that and said administrative proceeding, no confrontation clause.
In civil cases, we're subject to principles of horizontal stare decisis that says if we've made an old decision in the past, even if it's the wrong decision, we're required to follow it going forward until we agree en banc to change it, or until the CCA in this case would correct it. I mean, is that the same rule in criminal cases, I presume?
It is, but the CCA here has explicitly overruled it because all of those prior cases, including this court and Blunser, said that because revocation is administrative, the confrontation clause does not apply. In Ex parte Don, the CCA explicitly held that a revocation proceeding is not administrative. That really changed the landscape, and numerous courts, including Fort Worth and both the First and 14th and Houston, said that was the turning point. That overruled our prior decisions because we're not dealing with an administrative hearing anymore. And what's important about Doan is that the CCA is pointing to all of the similarities between a criminal trial and a revocation proceeding, right? It's judicial, it's adversarial, it's governed by the rules of evidence, liberty is at stake. Really, the only difference is the burden of proof being preponderance versus beyond reasonable doubt. So all of that is certainly pointing to the fact that this is part of a criminal prosecution, and that would mean the confrontation clause applies. I would also point this court to the CCA's decision in Parker versus State, where the court held that the Sixth Amendment right to counsel applies at revocation proceedings. There, the CCA noted that revocation proceedings cannot be isolated from the context of the criminal process, and it did refer to them as criminal prosecutions. So a revocation proceeding is an adversarial one with adjudication of guilt on the line. And if the Sixth Amendment right to counsel applies at this proceeding, then the Sixth Amendment right to confrontation follows. The statements here that were admitted through the probation records, furthermore, were testimonial. In De La Paz, the CCA said that a testimonial statement is one where the surrounding circumstances objectively indicate that the primary purpose is to establish or prove a past event potentially related to criminal prosecution.
Now, are you distinguishing between the two different sets of records that were admitted?
So what defense objected to was, I believe, Exhibit 16A, which was the Terry County probation records, the chronos that came in through probation officer Villalva.
Okay, so we're not talking about the Lubbock County.
No, Your Honor, there was no objection made there. But with the Terry County probation records, what counsel objected to were third-party statements, double hearsay essentially, within those records that exactly fit what a testimonial statement is. These are formal reports to a probation officer of alleged violations made by Mr. Gage. And the state showed neither unavailability of these third-party witnesses nor any prior opportunity for cross-examination. And again, because this is a confrontation clause violation, the harm standard that the state must meet is to prove beyond a reasonable doubt that this testimonial hearsay did not contribute to the revocation of Mr. Gage's community supervision and the adjudication of his guilt.
So again, on the harm analysis, how can you show harm given the fact that there was no objection to the Lubbock County records? And even if we were to exclude the Terry County records, there is still evidence to support the trial court's action.
Sure. The difference here is that the Terry County records had something different, had different testimonial statements than the Lubbock records. And I think the most clear example of harm would be the statements made about Mr. Gage's performance in the Batterers Intervention Program, one that he ultimately completed. But there were statements in there that he was incorrigible, rude, that he was not accepting responsibility. And that all came from this third party person who was overseeing that program. The actual probation officer who testified about this and the records that they came in had no personal knowledge of it. She had actually only been supervising Mr. Gage for a few months, 2 or 3 months at the time of the hearing. This was all done under a prior probation officer, but she was able to use that statement to paint Mr. Gage as someone who couldn't be helped anymore. He's not sorry. He was rude and disruptive in the program that we have to offer for him. He's worse than other probationers based on that statement, that third-party statement in the records. The probation officer concluded, I've never seen anything like this before. Nobody else has gotten a report like this before. And therefore, revocation is the only answer. And so even though there may be evidence, and we can see that there is evidence on the sufficiency ground, there's sufficient evidence of violations. But that is a different question than whether a confrontation clause violation caused harm. And it's our position that based on the overall conclusion the probation officer was able to draw and testify to based on these testimonial hearsay, that was harmful. And if there are no other questions, we respectfully request that this court reverse and remand to the lower court.
Thank you very much. Mr. Fuller?
May it please the court. I would like to first address a question that Justice Doss asked Ms. Groff as to whether or not this court has reviewed this issue since Doe. You have. In fact, Your Honor, Justice Doss in Estrada looked at this very issue. Excuse me. And found that, excuse me. I think I've skipped over to a different answer. I think this court has looked at the confrontation issue. Yes. Look at my notes again. So this court in Estrada in 2023, Justice Doss authored the opinion. And then in also in 23 under Murray v. State, which is 07230090 CR, Justices Quinn, Parker, and Doss addressed this issue. And then again in another Murray v. State, 07230013-CR, Justice Quinn, Justice Doss, and Justice Yarbrough. So everyone on the panel, and including our Chief Justice, has looked at this issue in 2023.
Were those transfer cases?
They were, no, the transfer case was DePauw. And that court, that was Justice Quinn who authored that opinion. And although he followed the second court's authority and precedent, it came to the same conclusion. But the others, the two Murrays and Estrada, were this court and this panel. And so, yes, you have looked at that issue.
But those were cases from within this district, the 46 counties of this district.
Yes, sir. And then DePaul was from Fort Worth. So all of these, there's really not that much of a distinction or a dispute. As for Doan did not address the confrontation clause at all. And if you read the Court of Criminal Appeals opinion in Hughes, and that's 691 Southwest 3rd 504, and it's a 2024 opinion. The court recognizes that Doan does not address the confrontation clause at all. And in this particular case, Mr. Hughes had been deprived of his right to be in the courtroom and confront the witnesses against him because he was limited to a Zoom hearing. And throughout the proceedings of the Zoom, Mr. Hughes was muted because he was speaking out of turn.
Without regard to saying, okay, this is what you've said before, just on the merits of the argument itself, why would a deferred adjudication not be a part of the criminal process?
Well, Your Honor, that analysis, I think, is an analysis that could be an academic argument. This is not the case for that. And the reason is that, let me read you the appellant's objection at trial, okay? Judge, generally, we don't have any objections, but specifically there are instances where people contact the probation office and make statements, and we feel that those are hearsay within hearsay, and we would like to have those redacted. As far as general entries by the probation officer, we don't have any objection to those, but if we're going to start getting into statements that are contained within the document that were made by a third party, then we would object to those as hearsay within hearsay. And all of the courts have consistently held that probation records are in fact an exception to the hearsay rule. And that is what happened here, was they were allowed in under business records exception to the hearsay rule. And then what we need to understand in the complaint about the hearsay within the hearsay is there was never any, the defendant never pointed out any of the hearsay within the hearsay that they wanted redacted. And the court actually followed the mandate against hearsay within hearsay, volume 7, page 279 through 80. The state asked a witness about a phone call from a third party. The defendant objected. The court sustained on the ground that the statement by the third party was hearsay within hearsay. Then in volume 8, page 24, the defendant elicited testimony regarding third-party statements in a third-party email, and the state objected that it was hearsay within hearsay, and the court sustained that objection. So the court followed all of the guiding principles of law, and you have to understand that in a probation revocation hearing, that is your standard, abuse of discretion. Did this court follow the standing rules of law? And he did at each turn. He followed this court's precedent. He followed the rules of evidence. He followed the rules of criminal procedure. He did not abuse his discretion. Now, the appellant is making a blanket argument about these constitutional provisions. That was not the unique snowflake of his objection. This court can only review the snowflake of his objection. This objection and the court's procedures do not give rise to this court overturning its prior precedent. And the appellant has not given you a reasonable basis to do so. As for Justice Parker's question about whether or not the defendant can show harm because The Lubbock County records were not objected to. And I agree that there's no harm shown by the defendant. And even though Ms. Groff made a lovely argument that there was some harm, the bottom line is he has to prove that the outcome would have been different. And that cannot be shown because there is ample evidence that he violated many terms, all of which were found to be true and violated.
Well, maybe we're playing a semantic game. I thought it was Ms. Groff's position that the burden was on the state to show harmlessness. You would disagree with that as being the standard?
I do disagree with that, Your Honor. At the probation revocation hearings, the burden for the state is preponderance of the evidence. And the state showed by preponderance of the evidence that he violated the rules against drinking. Jimmy Mercer testified that he was drinking. Michelle Deaton testified that he was drinking. Raymond Gonzalez testified that he was violent. Ashley Easley testified that he threatened his ex-wife. So there were multiple testimonial evidences of violations of those terms of his probation. And as Justice Parker pointed out at the very beginning, all you have to have is one, which means that the appellant has the burden to prove that each and every one of those violations was justified and that he was harmed by some evidence on each and every one of those violations. And as for the unsequenced argument, there is no mandate for bifurcation in revocation proceedings. And that is a long line of cases as well. Going back to 1999 and Pearson at 994 Southwest 2nd 176 Court of Criminal Appeals. All that is required is the opportunity to present evidence during the proceedings. There's no, I've got to find this first and then have this other. In fact, in Carl.
2A108 say after an adjudication of guilt, then the proceedings continue. I agree with you. It's unitary. It's a unitary proceeding. He hears all the punishment, all the evidence at one hearing, but it says after an adjudication of guilt. And here, the problem was he says, I'm not finding that, and then proceeds.
With all due respect, Your Honor, there is no adjudication of guilt in a revocation proceeding. The mandate for bifurcation.
In a deferred one, there is. There's no finding of guilt in a deferred one. That's why they defer it. The first step in revoking a deferred adjudication is a finding of guilt after the finding, right?
This is a probation revocation hearing.
Yeah.
With all due respect.
Right.
So, I mean.
It's not a deferred adjudication one?
No, sir. It was a probation. So and again, you know, we can have academic discussions, but for purposes of this unique appeal, this was a probation revocation. And so there was no finding adjudication of guilt.
So you're saying on the underlying offense, he was previously found guilty, served whatever punishment, or as a part of that, he had to meet certain conditions of his probation. This was not, we are deferring adjudication on the original charge subject to these.
Correct. Yes. And so he had, I believe he pled guilty. And so then the punishment was probation. And if you follow your mandates, don't drink, don't be violent, don't leave Lubbock County without permission, those types of, and he got transferred from Terry County. This is a Terry County case, but he moved to Lubbock. So it went, but it's originally it was don't leave Terry County. Then it was don't leave Lubbock County. If you follow all the rules, then you've completed your sentence. But if you violate your probation, then you are subject to going back to court. And if you found to be violated, if I found to have violated those terms and conditions, then the court can assess punishment up to whatever you agreed to in the pleadings. And he agreed to 8 years, and the judge only
Clerk's record 156 says 8 years deferred adjudication.
is that right?
Yeah, the state went to trial on an amended motion to proceed with an adjudication of guilt.
Okay. I apologize then. I apologize, Justice Yarbrough. I apologize. Well, I will say this,
Does that change your analysis?
It does
Just in
not.
light of that information?
It does
Or is
not,
the
Your
state
Honor.
Position the same.
it does not change my position because the law is consistent that unlike conventional trials, revocation proceedings are not bifurcated into distinct guilt and innocence phases. And there's actually the Carl case. It is out of Fort Worth 0208243-CR that found that that court did bifurcate and that it was error. Okay, so the distinction, the reason behind bifurcation.
I don't think even appellant is disputing the bifurcation unitary proceeding. I think we all agree it's unitary. The problem is the order of the proceeding in the one unitary proceeding. They proceeded with punishment evidence without an adjudication of guilt. Like they took it out of order. They can all do it in one hearing. That's the issue. What's your position with taking it out of order?
That I don't believe that it caused anyone any harm. And I don't believe that any of these cases that say that it's unitary would say that there has to be a complete bifurcation, that you can only hear evidence of violation without hearing anything about punishment. Because it always says, as long as the defendant had the opportunity to put in mitigating evidence, which this defendant did. And then I'd also like to point out again in the record, in volume 8, in page 114, the defendant rested without requesting to put on any more evidence. And then they closed without putting on any more evidence. And then the trial court asked, does either party request any additional sentencing hearing at this time if I revoke? I think either party is entitled to that if they wish to have it.
What is that still in volume 8?
Yes, ma'am. It's at volume 8, page 134.
Here's my problem. And I've after Hughes came out in 2024, the Court of Criminal Appeals just last year, May of 25, issued an opinion called Zubiate. And it says what you said is correct on a probation revocation. A probation revocation is different from a deferred adjudication, whereas we already have a guilt. We already have a guilty in adjudication, whereas a deferred, the guilt was deferred. And in Zubiate, they analyzed the entire situation to determine whether it's a criminal proceeding and, whether the confrontation clause applies, all sorts of issues. I am nervous based on Zubiate that they would hold without an adjudication of guilt like we do in a deferred, the confrontation clause and everything would apply.
Well, I believe the confrontation clause was satisfied.
Good.
And so that is why my analysis does not change. Mr. Gage was given all of his protections under the confrontation clause. And so this is not the case to have that academic discussion.
What were those protections? If I understood what you were saying a while ago, you were saying it wasn't really a confrontation clause objection. It was really hearsay.
And because that is what he argued, that's the argument that he made.
Okay.
Yes, I mean, that's the objection that he made.
So was there a confrontation clause objection that was made at the time of the hearing?
Not specifically, no, sir. I believe that the state brought up Crawford, which is the underlying case that would say
That, I mean, we don't require the parties to use magic words. I mean, if they're talking about Crawford, that indicates the confrontation clause, right?
But Crawford stands for the fact that it's a procedural guarantee which commands the reliability be assessed in a particular manner by testing the crucible of cross-examination, okay? And so as far as the objection to the Kronos records, so the probation records, and the right to cross-examine each of the witnesses under there, the law is very well settled that probation records can be introduced as business records. That's not challenged, even in their argument, or excuse me, their objection. They don't challenge that the records are an exception to the hearsay rule. So there's no violation of the confrontation clause with the exception to the hearsay rule. The complaint was the hearsay within the hearsay contained inside of those records. And when the hearsay upon hearsay was elicited by both the state and the defendant, the judge sustained the objection. So that information did not come in. So his rights to the confrontation and cross-examination were honored.
I want to make sure I understand the state's position. Are you saying that if the hearsay rule is satisfied, then Crawford isn't implicated?
No, Your Honor, I'm saying that Crawford is saying that it is satisfied. If the hearsay rule is, if there's an exception to the hearsay rule, then there's an exception under Crawford that you've met those standards.
I guess I'll go back and read Crawford. I just don't think I agree with you. I viewed Crawford as the right of confrontation that's guaranteed under the Constitution, and it's not about a rule of evidence.
Crawford was designed, or what I took from Crawford is that that the court rejected the view that the confrontation applies to only in-court statements, and that the introduction of out-court statements depends on the law of evidence. And our law of evidence provides a hearsay exception for probation records.
Your time is up.
Yes.
Further questions?
No.
Thank you for your time, Your Honor.
Ms. Brock, you'll have the 5-minute rebuttal.
Thank you, Your Honor. I'll start with the confrontation clause issue. Now, counsel for the state says that this court has held that since Doan, that the confrontation clause does not apply to deferred adjudication revocation proceedings. Counsel cited a couple of cases, Murray versus State. I will acknowledge I don't know those cases. They weren't cited in the state's brief. But my research all showed that the only times this court since Doan has held that the confrontation clause doesn't apply was when it was applying the rules of a transferring court. The state also pointed out that Hughes, the 14th Court of Appeals decision on this issue, said, well, Doan doesn't address the confrontation clause. That's true. But what counsel left out is that Hughes goes on to apply the principles of Doan to ultimately hold that the confrontation clause does apply, because everything that Doan was talking about the similarities between the revocation and the trial, those all point to the fact that this is not an administrative proceeding. I believe also that counsel is mixing up the standards for sufficiency of the evidence and harmlessness for a constitutional violation. Council did acknowledge in response to Justice Doss's question that the state does have the burden by a preponderance of the evidence to show that there are violations. We agree, that's true. But when we're dealing with a constitutional error at the hearing itself, the state has the burden to show beyond a reasonable doubt. That standard for constitutional harm still applies at a revocation proceeding.
Let me ask you this question. You know, frequently we'll have deferred adjudication revocation cases that come up. Frequently we'll have, there'll be 7 grounds for revoking somebody's deferred adjudication, and the defendant will plead true to one of those and, or challenge the other 6, and, they come out, whatever they come out. When a defendant brings up a case on appeal, they want to argue about those 6. We say, King's X, we don't go there because there was one ground that you didn't challenge. Isn't that same principle applicable here? I know we're arguing in a different way, and I know you're arguing it in terms of that it might have affected the length of punishment, for example. But it seems like if we're looking at our older authority on how we handle that, it doesn't matter in that sense.
Well, it would affect the length of punishment, but our primary argument here is that it affects the judge's decision to adjudicate. Right? The statute says that the judge can continue and refuse to adjudicate after a finding a violation. So in the situation that you mentioned, we agree to 1, we contest the other 6. The fact that we're contesting the other 6 likely means we're contesting that you should adjudicate, that's the appropriate answer here. So our position is that when there is a confrontation clause violation, the state still has to show beyond a reasonable doubt that violation did not contribute to the judge's decision to go ahead and adjudicate guilt, even if there was sufficient evidence for the violations. I also wanted to point out that counsel seems to be arguing that the confrontation issue was not properly preserved, that we only made a hearsay objection. And I just wanted to point the court to the record at volume 7, 268, I believe. The attorney, the defense counsel specifically said, Judge, about these chronos, Judge, they may be kept in the regular course of business, but that doesn't override the client's right to confrontation. They're made with an eye towards future litigation. So yes, there was a double hearsay objection made, but also a confrontation clause objection. And as opposed to what the state argued here, both in Crawford versus Washington and in Wall versus State, a CCA case from 2006, this is on page 18 of my brief, whether a statement is admissible under the rules of evidence and whether it's admissible under the confrontation clause, those are separate questions here. So the fact that these probation records could be admitted as a business records exception has no bearing on this court's confrontation analysis. Finally, I just want to point out that Justice Yarborough asked, doesn't the statute here say after adjudication? Doesn't that show there's a sequencing? We never got a clear answer to that question from the state, but it does. And none of the CCA precedent saying admitting mitigation early doesn't violate due process. None of that should lead this court to hold that the same result applies to aggravating punishment evidence. And we'd ask that this court reverse.
I just have one quick question. On the harmless versus harm, are you saying normally it's the appellant's burden to show there was harm? You're saying it's the state's burden?
When it's a constitutional violation.
Okay.
Yes, Your Honor.
All right.
Thank you.
Thank you very much. The case is submitted. We appreciate your presentation today, and we will take a 10-minute recess before the next oral arguments. Thank you.
All rise.